Joining me here in the studio to discuss this is Shefali Shah, who's with the Children's Legal Centre. Shefali Shah, so at what age do you think a child is competent enough to make this kind of decision?
Well, at 16, a child can make a decision whether to refuse or consent to medical treatment. If a child is under 16, then the test is not in relation to their age, but whether they have sufficient understanding and intelligence to be able to make the decision whether to refuse or consent. So it has to be an informed decision as to whether they understand the medical advice that is being given and the consequences of the decision that they're making.
But that's very difficult, sufficient understanding and intelligence. I mean, medical procedures are quite complex. Can a child as young as 13, for instance, really be able to keep up with all that?
I mean, it's a decision initially that the medical practitioner has to make, and if they are satisfied, then obviously they have to, it is basically their judgment call as to whether they are satisfied that the child understands the decision that they're making and is competent to make that decision. And in this country we often use the word Gillick competent, which originated from a case, and that is the test that is used not only by the medical profession but also in the legal process.
So there are going to be lots of agencies, one way or another, involved in this kind of case. I mean, you've got the medical profession, you've got the legal bodies, you've got the health authority, the local authority, the family and the child itself. So, I mean, what happens typically? You'd have to sort of assess or get together to try and work out what's in the child's best interest.
That's right. And if the issue arises that if there is a dispute, then obviously in this country we have the ability to take the matter to court, and then for the court to balance what the medical and the clinical views are in relation to what the child's views are. And what the court decides is what is in the child's best interest. That is their primary objective when they are considering these matters.
So what's in the child's best interest may not be the same thing as what's in the child's best medical interest, which is what the doctors are looking out for. But the case of Hannah Jones is made easier in a sense, isn't it? Because her parents were backing her.
Yes, certainly. Where you have a situation where a child is supported by the parents, then the court would take that into account. And if they are themselves informed, devoted and loving parents and supporting their child in making a decision, then the courts would take that into account. I think in the whole process, both the child and the parents have a voice in this, and for their voice to be heard.
But it's a lot harder, presumably, when the parents perhaps disagree with the child.
Absolutely. But again, the court is applying the same test. What is in the child's best interest? That is the main focus and the primary consideration a court will make.
And so when you have a child under the age of 16 like this, I mean, there are lots of kind of legal protections, aren't there, around? And I mean, what derived essentially from international sort of instruments, covenants like the child's rights, the UN Convention on the Child's Rights?
Absolutely, and as this country and other countries that have ratified the UN Convention, all countries will have their primary consideration as what is in the best interest of the child. Primarily, the interest will be to prolong a child's life. However, in this particular case, and the other cases where the treatment is very invasive and the prognosis is not certain, then the court will balance that in relation to what the medical advice has been given.
Okay, Shefali Shah from the Children's Legal Centre, thank you very much.
Thank you.